Good afternoon. I want to welcome everybody to our webinar today that we're going to have on choosing the right entity, business entity or structure for real estate investing. Is just kind of our ongoing commitment to educating our clients and our contacts on matters related to self-directed IRAs and real estate investing. We're happy to have this webinar today with our guest, who's going to be James Clifton of the Clifton Law Firm, who'll be joining us here in just a few minutes. I just want to remind everybody who's listening to this webinar live today, if you have questions as we go along, please type those questions into the chat box on your screen. I'll monitor those and make sure we get those questions asked. If you are someone who's watching the recording of this webinar at a later date, my contact information as well as our guest today will be at the end of the webinar as well. So just want to make sure everybody is aware of that. If you have questions, please just ask them in the chat box on the screen. We'll make sure we try to get to as many as possible. I know we have an attorney on today. We want to make sure that this isn't just free legal advice hour, but we're going to try to stick to the issues that are present. We'll try to get as many questions answered as possible. My name is Scott Maurer. I'm an attorney and also a certified IRA services professional. I will be your moderator today here at Advanta IRA. I do business development for Advanta IRA, both in our Tampa and in our Atlanta offices. And although I am an attorney, I do not give any legal advice. That's why I brought someone like James on today who can talk to you more about some legal issues or potentially give you some legal services and legal advice after the webinar is over today. My contact information is here. You certainly reach out to me with any questions you have on self-directed IRA accounts. Now, just kind of for those of you who may be new to self-directed IRAs and Advanta, let me tell you a little bit about what we do here at Advanta. We're a self-directed retirement plan administrator. We do have clients nationwide. What we do is provide a record-keeping and administrative service of holding your IRA accounts, doing the record-keeping, receiving income in, paying expenses. Again, those of you who have taken part in our other webinars and other seminars know that we get in a lot more detail on those classes. But we try to provide as much education, knowledge, and we really do focus on customer service here at Advanta IRA. That's our commitment to our clients and giving them the best possible service, and really trying to set ourselves apart from other custodians that are out there in that particular arena. We've been around since 2004, and combined within the company, the individuals who work here, we have over 20 years of experience. All the cash that we hold at Advanta IRA is protected by FDIC insurance. That is true of any IRA account insured up to $250,000. And again, we're currently holding over $700 million in assets. We have a network of CPAs, realtors, attorneys, other trusted professionals that we can refer you to. Sometimes they refer people to us as well. And again, our commitment is really to customer service, and that we have a concierge-style account manager system that every new account gets assigned to one person who will assist you regarding anything related to your account. And we try to, again, offer as much education as possible to our clients. We do that, again, on these webinars that like you're listening to today. We also have offices in both the Tampa, Florida area and also the Atlanta area where we do hold live classes at our office. We also quite frequently are in the community speaking at different events. So it's a real estate investing group, whether it's doing a 2-hour or 3-hour continuing education class for CPAs or realtors. We do a lot of that as well. So if you're in those areas, you'll certainly see us out in the community. And again, as part of our commitment really to educating our clients, we want individuals who are self-directing with us to have access to the resources. We know that this concept is new for a lot of people, especially when obviously they're first getting into it. So we really try to provide as much content through the seminars, the webinars, our website. We go to networking events, lunch and learns, really to try to help people really get a grasp on and get a firm understanding of what it means to self-direct your IRA account. We do have a learning center on our website. We also have a YouTube page where, again, if you're watching the recording of this or if you're listening to this live and want to go back and rewatch it, it will be placed on our YouTube page. There's also a number of other webinars on that page related to self-directed IRAs that would hope that you get some great value out as well. We certainly have a blog as well you can take part. We try to give you, again, just different points of view on a lot of different types of information that we can share. For those of you on the webinar, I'm sure most of you probably have heard of a self-directed IRA, but in case there's a few people that haven't, just to quickly define what these plans are before we really get into the meat of our presentation today and bring on our guest. But most people have not heard of self-directed IRA accounts because the accounts that they have, their IRAs, their old 401ks, are held with banks, they're held with brokerage firms who are offering them limited investment products. Self-directed IRAs really only account for less than 4 or 5% of total IRA investments. So it's a matter of most people haven't heard about it because they're not being told by their current custodian that they have other options. It's up to you as an individual to ask the questions. Maybe again you come to a class, you talk to a CPA or a realtor or an attorney who knows about this and can kind of clue you into what self-directed IRAs are. But it's really, again, you're not going to be told by your current administrator that it's possible to invest in real estate, notes, mortgages, and other entities that we'll talk about today. Now, as far as what accounts can be self-directed, any type of IRA, whether it's a traditional IRA, a Roth IRA, a simple, a SEP IRA for if you're self-employed, the SEP and the simple, and also the individual 401k, are great avenues for contributing more money each year into your plan, and also then in turn obviously having more control over what you're looking to invest in. So any types of these accounts can be self-directed into the types of assets that we're going to talk about that are here on this next slide as well. We see people invest into, obviously when we talk about self-directed IRAs, another term people might use is a real estate IRA, simply because so many of the assets that people invest in with their self-directed IRA are related to real estate, whether that be a single-family home for rental, a property that's being rehabbed, a piece of vacant land, notes, mortgages, other lending instruments as well that are tied, obviously, to real estate, whether real estate is the collateral or other types of investments. We also see some futures trading, some foreign currency trading, a number of investments into private placements or private stock, people investing in the hedge funds, maybe a private startup company. We also see a number of people invest into a single-member LLC that they call in the industry, quite typically, a checkbook control IRA or a checkbook control LLC. And that's what I'm going to talk about here for just a few minutes before I bring in our presenter today or our guest host. But a lot of people, we talk about checkbook control, and this is jumping forward a little bit for anyone who might be new to self-directed IRAs. This might be jumping a little bit too far ahead for you, but checkbook control with an IRA, and typically under a lot of, in just a basic IRA account, if it's held by the custodian or the administrator, in this case Advanta, would retain the uninvested cash in your account. We would receive the bills in that you need us to pay. We would deposit the cash that's coming in from your investment. So if you have a rental property, for instance, your tenant would send us the rent check. We would deposit it to your account for any of the expenses, the taxes, the maintenance, the insurance. You send us those bills. We pay those out of your IRA at your direction. So we are holding the uninvested cash, receiving the money in, and doing all of the record keeping associated with that. Now, the checkbook control account is typically utilized using an LLC, although, again, our guest host today is going to go in a lot of different types of entities, but it's quite often held. It's a situation in which you set up some type of entity. In many cases, we've seen it as an LLC or a limited liability company. By setting up this other structure enables you to move the cash from your IRA into this particular entity, this particular LLC. From there, if you are the manager or in control of that entity, you can write checks in and out of that LLC's bank account. So it's going to give you the ability to pay those bills, receive and deposit the income. That's why they call it having checkbook control. Advanta is still involved in this circumstance, holding your IRA is holding this interest in an LLC rather than holding the actual property and all the uninvested cash as well. So the checkbook strategy is typically one in which the IRA owns 100% of the LLC membership, and it gives you the ability to write checks, pay bills, etc. Just kind of how that structure works. An individual looking to pursue this option is, number one, setting up an account with Advanta, opening up the account and funding it, usually typically through transferring or rolling over funds. tax-free from either another IRA or an old 401k. The client, in this case Joe, would need to set up his LLC with the Division of Corporations and choosing the state in which he wants to do that. And the articles that are filed with the state that kind of establish the LLC would name Joe as the manager. And ultimately, the document that we need to see at Advanta is an operating agreement showing Joe's IRA as the 100% owner. That's, again, the document that denotes ownership is the document you need to provide us with here at Advanta IRA. We would sign the operating agreement on behalf of the IRA accounts once Joe has approved it, and then we can send the funds then that we've received by transfer rollover into the IRA. We can then send that out to the bank account to the LLC and allow then Joe in this instance to have the bank account opened. He can buy the assets in the name of the LLC. Now he has the cash in that LLC bank account to actually purchase assets, deposit rents from his tenants into the bank account, pay all expenses, etc., out of that particular account. So the checkbook control is just giving you kind of a little bit more authority. So I want to give a little bit of background on that before I bring in our guest host here. He's going to talk now primarily about choosing a business, the right business form. Our guest today is James Clifton. He's the founding member of the Clifton Law Firm. He's a University of Georgia graduate and also a graduate of the Florida Coastal School of Law. James is licensed to practice in Georgia, Florida, California, Texas, and Washington, D.C. He is a member of the Bar of the United States Supreme Court, a very distinguished designation. He's also a member and advisor of the Peachtree City Epic Group, a real estate investment club just south of Atlanta. So at this time, James, are you there?
I am here. Can you hear me?
Yeah, I can hear you just fine. So, James, what I'll do is I'll turn it over to you. And before I turn it over to you, I would encourage anyone who's listening, if you have questions regarding what we're talking about or tangentially related to it, please type them into the chat box on your screen. We'll make sure we get James to address that. But, James, I'll turn it over to you.
All right. Thank you so much. I appreciate everybody showing up today for this webinar, and I look forward to giving you a lot of information on business entities, business formation. We will cover a lot of information throughout this process. If you have follow-up questions that we don't get to during the webinar, my contact information will be the last slide, so please take that down and reach out to me individually, and I'd be happy to answer your questions in more detail. Business entities are notoriously detailed in how they are set up, how they are structured, the paperwork that goes into them, and a lot of times it can be very hard for an individual to try and get that set up for themselves. So what I'm going to do is go through all the different types. We're not going to cover every single type of business entity that exists. There are some types that are not really that pertinent to the situation at hand. We're not going to cover 501c3s or nonprofit organizations or anything like that, because I'm pretty sure all of you guys are out there looking to make some profit on the businesses that you're going to set up. Along with talking about the different types of business entities, I'm going to also explain how they may work in a real estate scenario, whether that is investing in real estate or in lending money in real estate scenarios. So let's get started with a brief overview of the different types of entities we're going to talk about today. We're going to talk about sole proprietorships, which essentially is just when somebody is operating a business without any set of paperwork or structure with the state in which they are operating. We're going to talk about partnerships, which is an agreement between two or more people to do business together. Limited partnerships, which we'll go over the details of those as well. Limited liability partnerships, which are statutory as well as limited liability. Limited partnerships, again, a statutory creation by the different states that are involved with that. And limited liability corporations, also known as LLCs. A lot of people like to utilize those, and I'll go over the reasons why and other things that you need to look out for when operating one of those. Corporations, there's two main types of corporations. We'll go over both of those, ups and downsides to each. And then last, we'll cover some trusts and what you can look for in trust scenarios and how they operate. Moving on to the sole proprietorship. The sole proprietorship is when an individual runs a business with no corporate structure whatsoever. So if you just decide to go out and start selling concrete blocks, and you don't have a corporation set up, you don't have a partnership, you don't have any sort of agreement set up, what you're doing is you are just generating income that, even if you're using a name like Bob's Bricks, you are generating income for yourself as an individual. All liability flows directly to you as an individual. All assets of you as an individual are subject to taking in the event that there is some liability that shows up during the course of business in operating that business. All taxes flow directly to the individual, and there is no formal paperwork that is required to start a business as a sole proprietorship. And one of the things that is really important to think about is that liability issue in this scenario. So if you're out there selling the bricks and the bricks fall over on Jane and Jane sues you for $1 million, your home, your car, your savings account, your checking account, all those things are then subject to the liability of those few bricks that you're trying to sell to Jane. That's why it is very, very, it's not a good business plan to have a sole proprietorship. Some people use it because it's easy. You don't really have to deal with a lot of paperwork, but the consequences of that are steep. And that is something that we always want to avoid. In the event that you have not insulated yourself from liability in the real estate realm, let's say you bought an investment property, put it in your name, John Smith, and you have a tenant who falls and hurts themselves because you failed to make an appropriate repair to the premises, and they sue you. That particular property that you own in your individual name is subject to liability, so they can get a judgment against you and then seize that property from you. Then they could come after your personal home and take your personal home from you and your personal car. Now, each state does have certain protections. If you were to file bankruptcy and things like that, it's a much more complicated situation. But the idea is not to operate as a sole proprietorship so that you can avoid any sort of bankruptcy filing or having to worry about that personal liability for things that happen within your investments. Moving on to the next stage, that is a partnership. A partnership is really just an agreement between two or more people that they will share the responsibility for profits, losses, liabilities, etc. Partnerships are pass-through entities. They are taxed as pass-through, so each partner, through their agreement, they get to decide how much of the profit each one receives. They get to, so it can be split up differently. One could have 50% and two could have 25%. There is no formal requirement that there is paperwork involved with this. It can be on a handshake between the parties. Obviously, if you're going to form a partnership, the best bet is to put together a partnership agreement that clearly outlines all of the responsibilities of each of the parties, what obligations they're going to have towards the partnership, what duties they're going to perform, what profits they're going to share, what losses they may share, because sometimes taxes can benefit to a certain partner better than another. So if there's tax consequences, you're going to want to outline losses. And then liabilities, obviously, if there are any liabilities, you're going to want to outline that as well. If the partnership is going to have a trade name, so it's going to be A, B, and C partners, you're going to want to file a doing business as or trade name designation. It varies state by state. Most of the conversation I'm going to have today, even though I'm licensed in 4 states in the District of Columbia, revolves around the state of Georgia, where I do a lot of my business. I also do a lot of business out of Florida, and I can answer additional questions about Florida as well. And I'll put in some other information on particular topics that are important. There's one that we'll talk about a little bit later in Florida that with LLCs. But like I said, there's no formal filing requirements to get started. But if you want to operate, you need to file a trade name designation and a partnership agreement. Like I said, you always want to put that in writing, and then you will need to get the required licenses and permits. As this pertains to real estate, this gives you a little flexibility with increasing the amount of money that you can generate, because you don't have to generate all yourself. You can have multiple people coming in to step up and put in different amounts of money, which always helps. One of the biggest drawbacks with partnerships is the exact same drawback that there is with sole proprietorships. It is not a recognized corporate structure that provides insulation of liability for the individual. So again, if there is an issue on the property, if there is an injury that occurs that is deemed to be the landlord's obligation, you have invested in this real estate as a partnership, each partner is liable for the damage that is caused to the individual. And so that is something that even if it is outlined in the partnership agreement, that is only so long as each partner is solvent. If a partner becomes insolvent, the additional partners have to step into that and have the obligation to pay those debts that are incurred. Obviously, the partner that has to step up for a partner who cannot pay has a claim against that other partner, but when they disappear and have no money, you're really standing there paying their bills for them. So that's another reason why partnership can be very precarious. Situations where it's not as precarious is when you have underlying business entities that form partnerships. In that way, you have created a layer of liability protection. So if you were operating an LLC and you wanted to partner with another person who was operating an LLC or someone who was acting as an individual, that LLC that you operate and the individual or the individual's LLC can form a partnership for the purpose of pooling money and then allocating profits and losses and liabilities. So there are ways to create partnership agreements that have liability insulation. However, if you're just doing this as an individual, there is no liability insulation when creating a partnership.
Hey, James, if I can just interrupt with one quick thing. Just want to make sure everybody knows if you're listening, do you have questions for James or also for myself as well, please just make sure you type those into the chat box. I don't have the ability to unmute anyone who's raising their hand, so if you can, just type as much as you can of your question into the box. We'll make sure we get those answered. So go ahead, James.
Fantastic, yeah. And questions actually make this go really well because it kind of gets into more detailed scenarios that you may be facing yourself. I'm covering this stuff with a pretty broad brush. It took me a whole semester of law school to learn a lot of this stuff and the detailed intricacies of it. So if you have any real-life scenarios that you want to kind of get an idea about how they would work, feel free to ask. So now we move on to limited partnerships. Limited partnerships are a interesting entity, and what it is it's comprised of a general partner and limited partners. And general partners are the people or the entities that maintain full liability for the partnership. So all debts, all liabilities, the general partner says, yes, I understand that I am going to be responsible for those in the event that we cannot perform on our obligations. Limited partners have a liability shield. They are only liable for their capital investment. So if you invest $10,000 in this limited partnership, then your maximum liability inside that partnership for the obligations of the partnership, whether it's a debt or whether it's a negligent injury or something to that effect, you are only liable up to your capital investment amount. This has become less common now that the statutory forms of limited liability partnerships and limited liability limited partnerships have come into effect. They are still used. Surprisingly, they're used in the movie industry quite a bit, which we're seeing a lot of in Georgia. And it's because one of the reasons that they're used is because these people who loan money to limited partnerships like to see the big bankroll of a general partner, and they know that the entity is serious about getting their obligation completed, and the general partner says, yes, we're that comfortable in completing this obligation that we're stepping in, taking on full liability, and we will make sure that this thing gets completed. So as far as all other aspects that we talked about in a partnership, those all are the same as far as allocation of how much profit each individual is going to make, or each business entity that's part of the limited partnership, and as well as loss sharing. and the only thing that's different is that liability piece. Now, one of the biggest drawbacks that you have to think about in limited partnership scenarios, if you're acting as a limited partner for that liability shield, is that it is very, very easy to lose your limited partner liability shield. And the easiest way to do that, because a limited partner has to be just an investor, just somebody who puts their money in, sits passively by, and takes their gains on the payouts. If the limited partners take any sort of form of control, have any sort of input in the decision-making of the partnership, of the limited partnership, then those limited partners lose their liability shield. And that is, there's a very good case on that called D'Escamilla, where two limited partners, the general partner filed bankruptcy, and the two limited partners were actually acting as making decisions for the partnership, and the court said that you guys are now general partners and you're liable for all the debts of the limited partnership. And those guys were holding a big, big basket of debt. So that's something that you have to work. Yes.
Yeah, if I don't mind to interrupt, that was one of the questions we had. You just touched on it. Somebody asked that can limited partners be involved in operating the business? And what you're saying is if they are, then they're no longer a limited partner.
Exactly. That's the whole point of this limited partnership, is that it is really just an investment vehicle for the limited partners. They are not in any control of the limited partnership. They are just there to essentially raise funds for the purpose of operating the limited partnership. And if they take any sort of role in that, then yes, they are going to lose their liability shield.
Yeah, and this might be something you're going to cover in a minute, but somebody asked, does an LP, a limited partnership, have to have at least one general partner?
Yes, a limited partnership is required to have at least one general partner, and the general partner can be a corporation, that is, or an LLC. That's not; these things can be hybrid, just like I talked about in the partnership slide, the last slide. They can be it can be padded with those additional shields, which can help, and it can help in creating an additional level of shielding on that. So that is definitely something that can be considered, but there has to be at least one general partner.
Okay, let me address one other quick question. We'll keep moving on. But so someone said, where can I find trustworthy information providing details or a cookbook approach to using an LLC, the checkbook control, to invest in rental property with regard to IRS filings and forms? Is that something, James, that you help people with? I'm sure.
Yeah.
Maybe have
sure.
a handout for someone, but
yeah. Well, we do. What we do is we typically have when we set up something like that for a particular investor, we give them the oversight manual essentially that says, here's what you need to do and here's how you do it. And one of the things, we'll go over this when we go over LLCs, but you got to be real careful when you're doing the checkbook control stuff. You got to be prepared. It's not for the faint of heart. You definitely want to make sure that you're going in prepared, because these little mistakes that you can make along the way can end up affecting you negatively on the tax side, and that defeats the whole purpose of what you're trying to achieve. So, and we like to work with our good partners like Advanta in order to get people prepared to do that. So that's something we'll cover a little once we get to the LLCs. Let's actually. Yeah. Do you have another one?
No. We'll a couple questions came up regarding LLCs, so we'll wait till we get to that part.
Okay, fantastic. All right, this one we're going to cover real quickly. It's limited liability partnerships. This varies from state to state. All partners have limited liability. Most states have changed their laws to reserve this only to certain professions. So it's typically professional associations like attorneys, accountants, dentists, doctors, architects, different things like that. And if you are holding real estate within a limited liability partnership, you would probably want to put it within its own business entity itself anyway, to shield the partnership from liability arising from the property itself. So I just wanted to put that out there. This is a particular entity. It exists in almost all the states, but it's treatment in the different states varies. So if you're considering something like that, or if you're, one of those professional associations, and you're thinking about this, I'd be happy to talk in more detail about that. But it's a very particular type of entity, so we're just going to touch on that one briefly. All right, limited liability, limited partnerships. This is a more a younger creation of the law. It was created essentially to give all partners in a limited liability, limited partnership, limited liability, as it says. It's comprised of general and limited partners, but in this particular setup, the general partners are also afforded limited liability. One of the biggest drawbacks to the limited liability, limited partnership is that they're not offered in all states. So if you are operating across state lines and you are not certain as to the effect of your limited liability, limited partnership in this other state, it could have pretty negative consequences because you could end up being treated as a non-limited liability general partner, and that's something that you obviously want to avoid. If you are only intending to operate within a state which does have limited liability, limited partnerships, such as Florida, then that it is a good investment vehicle to do that. It provides flexibility, like I said, with assigning liability and also with assigning losses. So it can be a very good investment vehicle if you are looking in one sole state that you are certain has that particular type of, offers that particular type of entity. Yeah, and like I said, if you're going into multiple states, this is probably not your ideal setup because of that drawback. But again, that's something that we can discuss in more detail if you're looking to go from state to state. The next one, this is the one that everybody likes to talk about, the limited liability company. The greatest part about a limited liability company is that it is so extremely flexible that you can do so many different things with it. There's no limit on the number of type of owners. So you could have owners that own from a trust. You could have owners that own from a S corporation. You can have owners that own from a C corporation. You can have individual owners. Those are all people who have invested in the company and have unit shares of the LLC. Owners are called members. They are entitled to certain rights under the Articles of Organization and the operating agreement. There are two different types of management inside of an LLC. They're member managed, where each investor who is a member has essentially a unit share, which is treated like a stock. Depending on how the operating agreement's written, different membership units can vote differently, just like with stocks. Then you could also have a member-managed LLC, where there could be 100 members who have invested in the company, but a manager or several managers operate the LLC much like a board of directors would, and those managers are elected by the members to manage the day-to-day affairs of the LLC. So again, that gives you two different types of management control, one where it's just a direct vote by the members, or one where they vote for representatives to represent the LLC. There are different membership interests to consider. We touched on this briefly. They're economic or right to income members, where you could actually change this into multiple levels, where there's a separate set of members who just get a paid dividend for any profits. And then you could also have the management or right to vote members who actually get to participate more in the day-to-day operations of the LLC or the election of the managers. All right, we got some more information on LLC. LLCs, to form an LLC, this is a basic rundown of what you're going to need to do. It varies from state to state, so you will need to check with your Secretary of State in order to confirm that these are similar to your state's particular offerings, but this is for the state of Georgia. You have to file the Articles of Organization with the Secretary of State. You must pick a unique name for the LLC. You may, but is not required to draft an operating agreement. I say may because there is no law that requires you to draft an operating agreement. However, any good business owner is going to have an operating agreement, whether you are an individual operating it yourself or you have 100 investors in the LLC, you're going to have an operating agreement that outlines all of the material terms so that you don't run into a serious scenario later. And what I tell people is that you may think it's expensive to pay an attorney a little bit of money up front to create some of these documents, but it's sure cheaper than hiring one to litigate this later, because that can get really expensive. So some of the things you want to think about in creating your operating agreement, it essentially acts as a contract between the members so that they all know their place and how they are going to be treated, whether economically or from management perspective. It also is the part that designates the management form. The articles of organization is where you make a special election if you want it manager managed. The operating agreement goes into the details of how managers manage, so what kind of authority they have. In relation to the real estate field, many operating agreements say that the manager or managers have to have a resolution in place in order to purchase real estate over X number of dollars. Or it may say, if it's member managed, that 55 or 65 or 75% of the members have to vote yes in order to purchase real estate over and above X number of dollars. And then a resolution will issue showing that the LLC has officially ratified the purchase of that particular piece of property. The operating agreement also can outline the requirements for transfer of ownership. This is really important if you want to, you only have a couple of investors and you really want to make sure that the people that you're investing with are not just transferring their interest to some people who you know nothing about their credit history, know nothing about their financial management skills or anything like that. So what you can do is restrict transfer to only certain individuals, or you can require a vote of the membership to approve transfer to another. And so that way you have control over what happens with the future management of the LLC. And then I mentioned previously, but guidelines for distribution of profit and losses. So that outlines how much each can make and how their assets and how the profits are distributed, or how the losses are distributed in any particular tax year.
All right, James, I had a couple more questions there. We can
Yep.
pop some of these in here on the LLC. Someone asked about if you have a loss personally, say from an asset that you own, you want to transfer that to the LLC. You're going to basically transfer the asset to an LLC that you own. Do you know how that loss would then be treated? I know you're going to get into taxes maybe in just a minute.
Yeah, and I don't
carry that loss
right.
to the LLC?
Yeah, see, that's a very personal question that you would need to talk to your personal tax accountant about, because I don't want to get into the thick of things with that and talk taxes and overgeneralize and provide somebody with the wrong information on that. Generally, the loss is going to be a loss of the individual, and it's going to be a rare scenario where it can be transferred to an LLC for the purpose of writing down the profits of an LLC. What is more likely, or a better scenario, is if you have losses to carry forward, you make an agreement with your other members of the LLC that you have individual loss that you can offset more profit of the LLC with. So you, in that particular year, take a larger profit from the LLC, offset it with your tax loss, and then in a later year, you can essentially give back that additional profit that you took in that year to offset your taxes. But like I said, I don't want to get too detailed in the tax consequences of that. We're going to touch on the topic of taxes, but it is going to be the overview. And for the more particular questions, we would consult with your tax professional on the best way to handle a particular scenario like that.
Great, that's a good answer. Another question, I think I maybe answer this one too. Are the details of the operation of the LLC created by the organization of the entity or by the operating agreement? I think what you just went over, it's the operating agreement that controls that, not the article. Right. I mean, what you file with the state is just kind of, here we are, here's our name, and here's who the manager is.
Yeah, the articles of organization are really just, it's like the table of contents for the book that you've written. And the operating agreement is the book. So the articles of organization say, this is the name of our company, this is where we do business, this is our agent for service of process. So if we get sued, here's who you send it to. We're going to be either member managed or manager managed, and I certify that all this information is correct. And you could put in special stipulations if you have something particular that needs to be of record with the Secretary of State. There are certain, depending on how many investors, there could be certain different things that you have to do with that, but that's a more detailed scenario. But then, so you have those articles of organization in place with the Secretary of State. Then you have your self-created operating agreement, or an operating agreement that's been prepared for you by a qualified attorney. And that is where you get into the meat and potatoes of how everything is organized, how the day-to-day operations of the company are handled, what kind of restrictions there are, if there's restrictions on the type of business that the company can do. We talked about there could be restrictions on the transfer of ownership. There could be restrictions on how the membership units are transferred upon the death of a member, whether there's a buyout clause for the remaining members. They can buy the deceased members' remaining units. There's all kinds of very interesting details that you can get into, and that's really where you define how you want your business run. And it's like I said, it doesn't, from a pure statutory perspective, it doesn't have to exist. However, it is very, very risky to run a business without having all those pieces in place.
Great answer. There's a couple of, a ton of questions coming in, which is great. I may not be able to get to them all this morning, everyone here, but somebody asked about having like an LLC series or a series of LLCs, and someone also asked about if you're holding properties long term, is it possible to hold each different property in a different LLC to insulate them from liabilities of other properties in the other LLCs?
Those are two great questions. Once you get into very long-term and you're investing in many properties, what you do is you need to set a liability threshold. And so if you're operating this LLC and you have two properties in it, the total aggregate value of the two properties is $210,000. And what you have to understand is, even though you have this liability protection in the LLC, the assets within the LLC are not protected from each other. So if on property 1 at 101 Lakefront Drive, you have an injury to a party that's deemed to be the owner's negligence, and they the court returns a judgment against you, then that judgment is also executable against 202 Lakeview Drive. So what you're doing is, by putting multiple properties into an LLC, you are making them each liable to the other for something that may occur unrelated to that particular property. So what a lot of investors do is they set their liability threshold. They say, all right, $75,000 is my maximum liability threshold. So I will only put $75,000 worth of real estate in this LLC. At that time, I will create a secondary LLC that I will operate in order to shield the property or properties in LLC 1 from the liabilities of LLC 2. And that could go on, you could have 100 LLCs if you're looking at, $1 million portfolios and things like that. The other thing is that, and I was going to touch on this a little bit later, but we've kind of spoke to it previously, is that you can create what we call an umbrella corporation or umbrella LLC that is essentially the operator of all of these underling LLCs that own small or little assets within them. So you'll have your big company up at the top, and then you have your little guys down at the bottom. And what we do is we set those little guys down at the bottom as pass-through entities, so the taxes flow directly up to your larger parent company, the umbrella, and then you set up your umbrella company with preferential tax treatment. And that way, all your taxes are passing through from your little guys down at the bottom up to your big guy, and then your big guy's getting all the tax breaks because it's making more money. You get more more things that you can write off up on the larger level, but all your business expenses from the individual LLCs at the bottom, your little guys, are still write-offs. You're just opening yourself up to more write-offs on a larger scale with your parent company. So that's kind of how, when we talk about a series of LLCs or multiple LLCs and how many you need, it's a question of what is your liability threshold, how much you feel comfortable having in each LLC, and then on top of that, we can structure it so that you may be able to get more preferential tax treatment by putting a parent company in charge of these little LLCs at the bottom.
Thanks, James. I have one more question. I'll let you move on. I'll make sure we get through everything. But two people asked basically the same question. Is establishing an LLC what state? Is it best to do it where the business is operating, or are there other states that are better for LLC formation than others, even if it's not your home state?
Yeah, that is something that we deal with frequently. Most of the time, it depends on what state. And here's one of the things I was going to touch on a little bit. In Florida, there is a case that when there's a single member LLC it's considered a disregarded entity for tax purposes. But there's a case out of Florida that has essentially eviscerated the liability protection of a single member LLC. And so operating a single member LLC is kind of up in the air right now as to how much liability protection you're actually going to receive from it. And that makes it pretty difficult to, as an investor, to say, all right, do I feel comfortable doing this or not? And obviously we can talk about alternates. Here in Georgia, the LLC is provided with a very, very strong defense, even if it's single member. It will require some severe wrongdoing on the part of the owner. Essentially, the owner would have to commingle funds, use the LLC bank account like a personal bank account, and if there was some showing of that, then the corporate veil could be pierced, and the individual could then become liable for the debts of the LLC. In regards to other states and how they operate, if you have a LLC in a foreign state and then you operate it within a other state, sometimes there are additional taxes that you have to pay, and that's because the state that you're operating or owning the property in wants to get some cut of the some of the revenue that you're creating from that. So there's other obstacles that you have to look at, and I can't say that there's a hard and fast state that everybody should go open an LLC in, because other than for many years, Delaware has been the site where people go to open corporations, LLCs, et cetera, because they have given all the preferential treatment and all of the deference from the courts to those particular companies. So that is one place that we often see companies go, and people ask us to assist in setting up companies in Delaware. So, but as far as that goes, typically, you're going to get the best tax treatment by having the LLC in the state of the property, where the property is located. But like I said, it's case by case, because there are states like Florida that have serious legal and technical challenges to look at when the LLC is in that particular state. And I think there was another part to that question, but I'm not sure if I.
No, I think that covered it. So
okay.
I'll let you, Jim. I'm gonna let you finish up the rest of your slides, and then hopefully we'll have a few more minutes to get to a couple more questions.
Okay, fantastic. And the rest of the slides are going to go by relatively quickly. Corporations are going to take up a little bit of time because of the tax consequences of that. But we'll move on to LLC taxes. I talked about the malleability, or the ability to change a LLC, how you can go from one thing to another. All you have to do is file certain paperwork. One of those great things is the tax consequences. By default, the LLC is taxed as a partnership if there's multiple partners or multiple members in the LLC. If there's one single member, then it is treated as a disregarded entity by the IRS. So that means all taxes flow naturally back to the individual who owns the LLC. The LLC can make an election to be treated like a corporation. for tax purposes. You would have to file the entity classification election with the IRS. I think it's Form 8821. Don't quote me on that. I can get you the exact form if you need it. But what you can do through that is form an LLC and then have it taxed like a corporation, whether an S corporation or a C corporation. And we're going to go over those two things in just a second when we talk about the corporation slides. Tax selection can be changed at will. There are certain filing requirements with the IRS that you have to do it within certain time frames in a particular year, but you can change as long as you meet those IRS qualifications. You can change your tax how you want to be taxed pretty much at will. So if you pick something and you're like, no, this is not working for my particular tax scenario, then all we have to do is file the entity classification election and get you changed over to something else. All right, let's talk about corporations. There's two major types of corporations. There's the S corporation and the C corporation, and they have a lot of similarities. Most of their dissimilarities, almost all of them, are tax consequences. So what we're going to go over is the similarities first. They're both separate legal entities that shield you from liability. So there's personal liability from any debts or obligations of the corporation, and the corporation is shielded from any personal debts of the individual. The corporate management structure is the same for companies. They typically have a president, vice president, secretary, treasurer, CEO, CFO, COO, and they have a board of directors that makes decisions on behalf of the company, hires and fires the president and vice president and so forth and so on. Easy transfer of ownership with the corporation. It's a stock transfer. Most stock transfers are handled electronically nowadays. You got to keep good books when you do that. That's one of the more difficult parts, but it's a relatively easy process. The corporations have a perpetual business life unless you set within their bylaws some date on which you would want them to terminate. The corporation will have an unlimited existence. Tax deductible expenses. They both have a lot of tax deductible expenses. Like I said, we'll go over some of the bigger details on the tax consequences in just a second. Self-employment tax. Both offer savings on self-employment tax. You have to pay yourself a salary by operating either of these, and what that does is that then gives you the ability to take dividends that are not subject to the self-employment tax, and that'll save you a pretty good chunk of money when you're talking about your end-of-year returns. The C Corp, this is the default. So if you file for a corporation and you don't make a special election, you are going to be treated like a C corporation. One of the biggest drawbacks of the C corporation is that there is double taxation. The corporation itself pays taxes, and then the shareholders all pay taxes on their gain that they take from the shares. And we call that, in our world, the double taxation of C corporation. I can talk in more detail at a later time with you individually if you're thinking about C corporation, because there are a lot of extra deductibles that you can take under a C corporation, but you have to balance that with that double taxation that may end up costing you more in the long run. The S Corp, on the other hand, is pass-through taxation, and that comes with their limits as to you can only have 250 members in an S Corp, and they all have to be natural people. So you can't have other corporations, LLCs, trusts, etc., investing in an in an S corporation, and that's because there are great tax advantages to the S corporation. You don't get that double taxation. You get the benefit of the non-self-employment tax on the dividends. So that's one of the reasons that's a really, really good tax vehicle. All right, corporate formation. Choose a unique name. It must end with incorporated, corporation, company, or limited. You file the articles of incorporation with the Secretary of State. It outlines the name, registered agent, authorized shares. The incorporator names are the people who have created the company, and the principal address of business. This is akin to the articles of organization of the LLC. It is the table of contents for the operation of the corporation. Then you create the bylaws, which are the operating agreement. They're like the operating agreement, and they outline all the different day-to-day operations of the corporation, how the board of directors, how many members, how they're elected. It tells how many officers there will be, such as CEO, CFO, COO, and so forth. So that's very similar to the LLC in that regard. Filing fees, and this is the state of Georgia. It varies from state to state. It's pretty easy to look up if you go to the Secretary of State's website for the particular state that you're looking to organize in or to incorporate in. They will typically give you a laundry list of fees. In Georgia, it's $100 to file your corporation or LLC. If you're filing a corporation, this is one thing I didn't talk about. The rules are more antiquated with corporations. And so with the LLC, all you have to do is file something with the Secretary of State. With a corporation, you actually have to publish the notice of incorporation in your local paper, letting everybody know that there is a corporation being formed. And that's really just because the legislatures haven't changed that antiquated law. The filing fees or the publication fees varies from county to county. It can be anywhere from $80 to $200. If you're going to do business other than the name of the corporation or LLC that you're operating in, there is a doing business as or DBA fee that you're going to have to file locally with your clerk of court. The purpose of that, so let's say I have James Clifton LLC and I want to advertise and hold out my business as the greatest law firm of all time. I have to go and file doing business as in the where my principal address is, where I'm doing my business in. I have to file with the clerk of court saying James Clifton LLC is also known as this entity, so that if anybody was to say, I have a debt that's owed to me by the greatest law firm of all time or whatever I said, then they could go to the clerk's office, find that that is actually James Clifton LLC, and they would actually have to sue James Clifton LLC in order to cover that debt. And that's the reason for that, is because there were many people who couldn't find who they're looking to sue, and so they had to create a database of doing business as. And if you operate without your doing business as, you can get in trouble if you're actually operating, because they may deem you a sole proprietorship if you do not have that DBA in place. And then there's also a publication fee for the DBA. Trusts, we'll cover this really quickly because we don't see them too often. I get a lot of questions about trusts, and it's a great estate planning mechanism. It's not the greatest real estate holding mechanism. A trust generally is just a device where someone manages property for the benefit of others. The person who manages it is called the trustee. The property that is in the trust, it can be jewelry, it can be cars, it can be real estate. That's called the res or the corpus. The creator of the trust is a settlor. And then the beneficiaries are the people who benefit from the proceeds of the trust. They have different names. You can see them there. A trust does not even have to have a formal writing. All there has to be is an intent to create. So if somebody puts a bank account together and says, this is in trust for my children, you may have the bank may get upset with you, but if there is some formal intent to create a beneficiary mechanism where somebody else is paid from that, the courts will make that work. It's been long held by the courts that they're not going to let a trust fail just because there wasn't a writing, so long as there's a person who had intent to create a trust and their beneficiaries designated. In regards to IRAs and real estate holding, the IRA itself cannot be the settlor of a trust. It's kind of a legal fallacy to have that happen. The individual that owns IRA can be the settlor of a trust, but that's something that you can go into more detail with your IRA administrator about, as far as creating a flow-through trust to beneficiaries after your death. But what we see a lot in investing in real estate through trust is through real estate investment trusts. And what these are is these are specific legal entities that have been created that hold tranches or sections of real estate or real estate debt, like mortgages, notes, things like that. And you can invest in those particular things yourself. And they essentially issue stocks that they're not called stocks, but they essentially issue stocks. You buy a portion of that real estate investment trust and you hold it as an investment. It goes up and down. There are indexes that follow these things, and that is really how you would invest in a trust through an IRA. one of the biggest drawbacks if you are holding real estate in a trust as an individual is that real estate has very little protection from the liabilities of you as an individual, because the law has very clearly stated in many cases that an individual who creates a trust and benefits from it themselves during their lifetime, their assets in that trust are liable for all their individual debts, because you can't just shield it by saying, here's my trust, I'm putting everything in it so I can go act recklessly and none of this will be affected by it. In Georgia, even if you have separate beneficiaries named, like you name your children as beneficiaries of your trust, there is still liability. The trust still has liability for your debts. And so that's why I typically caution people from holding real estate outright in a trust. I would typically tell them to layer it by putting the real estate in an LLC or an S corporation, and then having the trust hold the shares in that LLC corporation. I know I'm running out of time here, so I'm going to try and move a little quicker. I think we're getting pretty close to the end. One of the things about the IRS is that they do not allow investment in S corporations anymore. So if you are thinking about investing in real estate through your IRA, you cannot do it through an S corporation. So that kind of limits you to C corporation, LLC, or one of the limited liability, limited partnerships, or other limited partnership arrangements. When you have a C corporation, one of the things you have to consider is the self-dealing provision of the IRS code, which essentially prevents you from being directly involved in the income or operating of a particular corporation. So if you're making individual income from the corporation as well as keeping the stock in your IRA, the IRS is probably going to take issue with it. There are very, very technical ways to get around that, and you would need to speak very closely with an IRA professional and a tax professional and an attorney. So if you are considering a C corporation, please make sure that you proceed cautiously if you're putting that into your IRA. Unless it's a C corporation that you have nothing to do with. It's just a simple stock investment. If it's a C corporation that you're actually involved with, that's something you may want to be careful about. We talked about the trust issue. And then last, due to its flexibility, the LLC is oftentimes the best business structure to operate inside of an IRA. And like I said, you can change it at will. There's things that you can do to make this one of the best investment vehicles. Personally, I like the LLC, especially in Georgia, where it has great protections, even if you're a single member LLC. And then you can elect in that LLC to have either a S corporation or C corporation taxation, so you get some additional tax benefits instead of just pass-through taxes. So that's another consideration. With that being said, my contact information is here. I hope you've enjoyed the presentation. I'll be happy to answer a few questions if we have any more questions.
Yeah, actually, James, we have a ton, but I'm
okay.
going to limit it to just a couple because we are over time, and I also want to be certainly respectful of your time too. But yeah, great information. I think one of the things someone brought up was single member LLCs. Somebody asked, do you have to have can you have a single member LLC? The answer is you mentioned was yes.
Yes.
It's a matter of liability protection. Someone else asked, following up on that single member LLC, was do you need to have an operating agreement for an LLC, or do you recommend having one?
I recommend an operating agreement for any LLC. And the reason I say that is obviously if you're operating it yourself, you know what you want to do from a business perspective. But consider what may happen if you're incapacitated or you pass away, and there's no clear delineation on what you want to happen to your shares or your membership units. That's really, that's just one of the many scenarios that you can avoid by setting that operating agreement in place as a single member LLC in advance. And there's multiple issues that can be addressed by that, but I would always recommend having that operating agreement and, sticking to it, because anytime you deviate from the plan, somebody's going to try and undermine that to get to your personal assets. So if you have it in place and it's right on target, then you're not going to have to worry about that liability attaching to all your assets that you own as an individual.
All right, let's see. Another question. Someone asked, from a protection perspective, is it better to form a newly formed LLC to file as a partnership rather than a C Corp or an S Corp? I'm guessing from a protection perspective, does that matter? I mean, that's the S Corp, partnership, and C Corp are taxation issues.
Yep, that is
liability issues.
Yeah, those are all taxation issues. Once you have the LLC in place, your liability shield is up unless you mess up. The taxation part is what you're looking at between partnership, C Corp, and S Corp. I typically, if the investors are correct in an LLC, because it has the same limitations as S Corp taxation, but if you have all the right pieces in place, under 250, all natural human being investors, then the S Corp really, most of the time, is going to provide you with the best tax consequences for operating a business, mainly because of the self-employment tax that you're going to avoid by paying yourself a salary and then taking dividends on all income above that salary.
All right. Let's see. I had one question I wanted to get to. It's a little complicated, hopefully not too complicated, but revolved around having UBIT tax issues. I thought it was a good question to ask. When you invest in real estate in an IRA and you have debt, you have a mortgage on the property, an IRA can incur UBIT tax. The individual wanted to know what the thoughts are on using a C Corp to reduce the effective UBIT. If this is a tax question, that's fine. We can defer that person to a CPA, but I didn't know if you had any thoughts on that.
Yeah, it gets complicated, and that's a better question for a CPA. I can just tell you that it is a complicated scenario. When you're in, one of the things that you got to look out for with the C Corps, though, is whether you're actually going to incur a greater tax liability because you switched to that C Corp. Whether your gains from this other move that you're making are going to offset that. So you really gotta analyze that closely, and it's going to vary from person to person because it depends on what your particular income structure looks like, what your assets look like, what your total debt service looks like. So you got to look at all those different factors in order to come to a conclusion on that, a specific conclusion on that. But I'm not saying it's out of the question that could be a more beneficial scenario.
You mentioned earlier too the case in Florida. I think it's the Olmstead case.
Yes, the Olmstead case.
On the lack of protection for single member LLCs. A couple people asked if they're doing you have a single member entity in Florida, what do you recommend if as an alternative to the LLC in that situation?
Yeah, I would recommend an S corporation. If it's just one individual operating the business, I would recommend an S corporation, and that's where you get your liability protection. And the courts, to my knowledge, have not said that a corporation has no liability shield. So I was really surprised that the courts went the way they did in that particular case. It was a complicated fact pattern where it looked like there was a shell game going on. And I think that's why. I don't know exactly what the judges were reasoning when they thought they gave us a pretty good explanation, but that's probably had something to do with it, is that they said enough is enough. This person's they're not acting as a company should act, and therefore we're not going to give them liability protection. But my recommendation would be to set up an S corporation, and that will give you all of the liability protection, and it will give you all the tax benefits of the S corporation.
Yeah, another good answer. And then on the IRA side of things, to answer that question, the IRA side, as James mentioned, an IRA cannot be an owner in an S corp, so it's kind of a difficult situation when it comes to just your IRA. I can say that most of the people that use the LLC with their IRA are not always doing it from a liability standpoint, but doing it more so for the ease of access to the funds. So having that checkbook control authority, it's more of a device for that as opposed to a liability or protection tool. So hopefully that answers that question. Go ahead. I'm sorry, go ahead.
Well, I was just going to say that case, the Olmstead case, it didn't deal with an IRA. So the facts are going to be different. So the court may come down differently in a scenario where an LLC is operating within an IRA. That's not out of the question. However, if we're talking additional liability protection, you're getting into a more difficult question with how Olmstead interacts with an IRA in Florida. Yes, that is a very difficult question. and we could create something. We can get something creative going to avoid liability issues.
All right, last questions here. Someone asking about trust. Can you use a trust to move real estate assets into an LLC? I'm not quite sure I understand that question.
I mean, if you're simply looking at transferring property, I'm not exactly sure where that question is going either. But if it's just like my trust holds property, can I transfer it into an LLC? Absolutely. You can then transfer the LLC membership units into the trust. Very easy to do that. That gives you that liability shield. I think that's kind of what they're getting at. I'm not 100% certain that that's what the question is getting at, but if that is, I hope that answered it. If not, take my contact information down and we can get you a more specific answer.
Yeah, and then to follow up to that was something, can a person leave an IRA to the trust to invest in real estate? I can answer.
That's a great question for you. Yeah.
Yeah, you can name a trust as a beneficiary of your IRA account. There are definitely some pros and cons to doing that. If you leave your IRA to a trust, the trust inherits the account. It could be the inherited IRA owned by the trust can then certainly invest in real estate. We also have seen circumstances where IRAs have invested into private trusts, but on your IRA account paperwork, you're still leaving the trust to maybe a spouse or children or other family members as your named beneficiaries. So, again, that's kind of a complicated question. I would encourage you to call me as well. Again, we've run it way over time. I think we've just had some great information. I can tell by the number of questions we have that everybody was engaged and getting a lot of good information. So, James, I really appreciate you for taking time to join us today. I would just encourage anyone who has questions. James's information was up there on the slides. We'll be sending out the recording of this presentation today as well, so you have that. My contact information is here on the last slide. So again, James, thank you very, very much for joining us today. I'm sure everybody got great information.
My pleasure. Thanks for having me. I'll be happy to come back anytime.
All right, great. Well, we'll probably have you back. So again, Thanks everybody for listening today.
Thank you.
Thank you.